Hello, everyone. Welcome to Joe the Lawyer. Today, we're going to talk about a bill that is currently in the House of Representatives, the Pennsylvania House Legislature. It's called House Bill 1397, which promotes 50-50 custody for parents in custody litigation. Hello, everyone. Welcome to my show. I'm Joe Pometto, a practicing Pittsburgh attorney. I don't usually talk about family law, but I'm starting to get into that area more and more. I find it interesting. I want to learn more so I can help my clients. So today, I want to inform you a little bit, and I also learned a little bit myself while researching. There's a bill, and as you may know, I practice law in Pennsylvania. There's a bill in the Pennsylvania House Legislature, in the state legislature. It's currently before the House Judiciary Committee, and it's called House Bill 1397. And what it does is it promotes 50-50 custody. Well, you would say, what does that mean? Doesn't that already exist? Or perhaps some of you have been on the wrong end of a custody battle, say, there's no way that exists. It sounds like great news. So let me tell you what the law currently is. Currently in Pennsylvania, you have a concept of primary custody and partial custody. Now, whenever two parents enter into custody litigation, one or both parents is going to seek primary or they're going to seek partial. If a parent only seeks partial, okay, then they're not looking for 50-50 or 40-60. They're just looking for some custody of a child. If they seek primary, then they want to be the primary custodian. I don't know all the nuances, but more or less that's how that breaks down. And currently, when a judge has to make a decision either through the custody litigation process or finally at a custody trial where both parties put on their evidence and ask for the judge to rule in their favor, the judge takes into account what is called the best interest of the child. And there are certain factors that play into the best interest of the child. I think there's many of them, so I'm not going to list them here, but they are the kind of things that you would think. Is the child's schooling be preserved? Their community, which house would be safer, etc. Things like that. So that's more or less how it breaks down currently in Pennsylvania. A judge can say, I think that in the best interest of the child would be served if the child spent, say, 4 out of 7 days with the mother, or let's say 5 out of 7 days with the mother, and then they list their reasons why. And that's what you'll get at the end of a custody hearing. So what this new law would do is it would look to push the envelope closer to 50-50. What it would do is create a presumption of shared custody where the court is supposed to rule in between 40 to 60%, which would be 50-50. So what the new law would say is instead of just taking into account the best interests of the child, what a judge must do is they must go, there's a presumption. So the starting point is 50-50, and if the judge is going to veer from that, they have to state their reasons. And what the proponents of the new law believe is that this would get families to, I don't know if family is the right word here, okay, but it would get parents and children closer to 50-50 custody. Some of the reasons for this new law are, and these are the proponents of it, they cite that currently only 15% of cases end in 50-50. So that would mean 85% of parents with children who are divorced, separated, not living together for whatever reason, 85% of those cases currently don't have 50-50 custody. And the proponents of this law want to push that number up. Okay, and what they've done is they've cited research. I've seen a couple of studies, but there's a preschool study of children, I believe 4 and 5 years old were studied, and what it said was in families that are separated, that children who have close to 50-50, so 50% of the time with mother, 50% with father, or whoever the parents are, show fewer negative psychological symptoms. So they believe that this would be a way of getting to 50-50 and reducing perhaps psychological issues that can develop in children. If the judge was going to veer from this 50-50, he would have to state his reasons why, which honestly would not be that hard. What I question on these studies is this causation or correlation? So like they said, only 15% currently have a 50-50 scenario. Well, that's because the two parents in that 50-50 scenario, they may get along very well, and they may be very proactive and good parents at parenting a separated family. Okay, so what I'm saying is the children who currently have 50-50 may not be getting less psychological symptoms because they're spending equal time with mom and dad. It may be that mom and dad just get along really well, okay, and therefore they are able to raise a child with fewer psychological symptoms. So I have to wonder if, this push towards 50-50 would actually do what this study says that it does. What I'm arguing is I don't know if this study shows causation or correlation. Perhaps, those 85% are scenarios where there's not 50-50 and these kids have worse psychological symptoms. Okay, well, is pushing is pushing more of one parent on them actually going to be the better thing for them? Okay, it may be that one parent's already maybe not a good parent. Okay, and it could actually possibly do more harm to push them into the scenario with that parent rather than with the parent they have the majority of the time with now. I guess what I'm saying is that it's complicated. I would really have to see a lot more studies to say that pushing people towards 50-50 is necessarily going to result in fewer psychological symptoms. Proponents of the old law say that currently the judges look at the best interests of the child, okay? And the judge is in a position to become knowledgeable about the case, knowledgeable about all the issues facing the children, okay? And if the judge sees best that one parent should have more than another parent, generally there are reasons for that. There could be a history of abuse. There could be a history of alcohol addiction on one side or other, or perhaps it can come down to, monetary or financial reasons. Okay, so, I haven't done that much family law. What I have seen is that usually if both parents really want to get towards 50-50 or something like 40-60 and they're really proactive, even with the current law the way that it is, the courts are working to make that happen. I don't know if they necessarily did in the past. What I hear, and I more or less believe it, is that in the past there was a lot of focus on the mother getting a majority of custody time. I don't have stats to back that up, okay? What I see now in my practice is that, oftentimes the mother tends to get a bit more custody, but usually that's because the father may work a lot, okay? Or the father has a situation where they live further from the school and the community that the child is close to, and oftentimes the father is okay with taking less than 50-50. Now, I don't want to say that's true all the time, but I've seen that probably more times than not. So I'm really up in the air about this law. I don't know if pushing people closer into 50-50 is a good thing. However, this law still allows a judge to be creative because he can veer from it as long as he states his reasons, which really is not that different from the current law, which places the emphasis on the best interests of the child. And the best interests of the child would still be part of the current legal framework. One thing I do like about the new law is the whole concept of primary and partial custody is a little bit ridiculous. And I say that for procedural reasons. Like if you file a partial custody complaint, you have to do certain procedural things to then ask for primary. And if you ask for primary, you got to, there's almost procedural things to get down to partial. I think that distinction is ridiculous. Okay. So the new law, to the degree that it abolishes asking for primary or partial, I think is a good thing. It will put a little bit more emphasis on 50-50. Again, that would be the starting point, and maybe that actually is the right way to go. A judge would still have room, okay, to not do a 50-50 if he didn't think it was best or if the parties didn't actually want it. Now, the proponents say 15% get 50-50. I imagine if this law was passed, I don't think it would change that much, but it probably would bump up to say maybe 25%. And at the end of the day, that would be a good thing, because I can tell you a lot of fathers come to me and they feel like they get railroaded in this process. And this new law would probably, I'm just putting this out here from what I've seen, would probably benefit a lot of fathers who actually do want to be more involved in their child's life. And it wouldn't take away tools that the court can use to restrict custody if that person is a negative influence for one reason or another. So if you want to look into it, House Bill 1397 in Pennsylvania, I'll do an update if and when it's passed. It may be passed with amendments. I hope that you found this interesting. I want to give you updates on the law. Follow legal news. I'm a lawyer, Joe the Lawyer, Pittsburgh attorney. I do criminal defense. I do family law. I do personal injury. Okay, if you like this content, please like, subscribe, comment, and share. Subscribe to my channel. It's new. I got to get my subscriber count up. It will get me to keep making more videos because YouTube rewards me for that. Also, share this video. These are free ways to support this show. If you share, I'll get more subscribers. I'll get more views. Also, sign up for my email list. You'll get a free PDF on what to do when stopped by the police. I'm also going to send you other free stuff and updates. You can unsubscribe from it at any time. Thank you for tuning in.